Alors, bonjour, chers collègues.
Hello, colleagues. Good afternoon. I call this meeting to order. Welcome to meeting number 124 of the House of Commons Standing Committee on Industry and Technology. Today's meeting is hybrid. Pursuant to the order of reference of Monday, April 24th, the committee is resuming consideration of Bill C-27, Digital Charter Implementation Act, the short title, and we are continuing clause by clause consideration of the bill. Before beginning, I would like to remind all members and all other meeting participants in the room of the following important preventive measures to prevent disruptive and potentially harmful audio feedback incidents that can cause injuries. All in-person participants are reminded to keep their earpieces away from all microphones at all times. As indicated in the communique from the speaker on April 29th, the following measures have been taken to help prevent audio feedback incidents. So all earpieces have been replaced by a model which greatly reduces the probability of feedback. The new earpieces are, by default, all unused earpieces will be unplugged at the start of the meeting. And when you're not using yours, please place it face down on the middle of the sticker for this purpose. You'll find on the table. Please consult the cards on the table for guidelines to prevent audio feedback incidents. And as you can see, the room layout has been adjusted to increase the distance between microphones, and these measures are in place so that we can conduct our business without interruption and to protect the health and safety of all participants, especially the interpreters. Thank you for your cooperation. So with that, I would like to welcome back our witnesses, and thank you all for being there. Samir Shabra, Director General, Marketplace Framework Policy Branch, and Runa Angus, Senior Director to Strategy and Innovation Policy Sectors. Thank you for joining us today. And at our last meeting, we left off debate on the block sub-amendment to CPC 7. Mr. Van Bynen, you had the floor when we adjourned.
Were you Mr. Van Bynen? So the list is open. I recognize Mr. Perkins.
Thank you, Mr. Chair, and thank you, witnesses, for being here again. I'm sure it'll be great, very good, even though our regular Mr. Shan is not here. We'll muddle through, I'm sure. I think, just for the record, over the last week, we've had a lot of conversations about the CPC 7 amendment and the sub-amendment from Mr. Guérin, and what we could do going forward to find a way to make this work for all sides. And I think we have a compromise. It involves, from our perspective, supporting Mr. Guérin's sub-amendment to CPC 7. And if we get through that positively, I would then propose a new sub-amendment that I think will add some language and soften it up and make sure it works for everyone.
Thank you, Mr. Turnbull.
Thank you. And yes, I agree that there's been some really good conversations. And so I think I'm hoping that we're at a point where I feel that what Mr. Perkins has drafted and circulated is where we want to end up. I know that we are in consideration of Mr. Guérin's sub-amendment. I think what we've agreed is that in conversations before the committee meeting, that procedurally, I'm not sure what the best way to move forward is, but perhaps we can vote in support of Mr. Guérin's sub-amendment. And then I understand Mr. Perkins will introduce, I guess, a sub-amendment to that. I would just say, obviously, there's a little bit of a leap of faith in terms of that's how things will proceed. But as long as the committee members are clear that that's the way we will proceed, and we will land on the wording that Mr. Perkins has circulated, which includes the word may. And I think that's really significant, based on the testimony we had from our officials, that word makes a big difference in terms of how the law would be interpreted. And I think it's important that that's where we land. So as long as that's where we're all in agreement to land there, then I have no issue with moving forward and voting in support of Mr. Guérin's sub-amendment, and then voting in support of the changes that Mr. Perkins has put forward. Thanks.
Thank Thank you very much, MP Turnbull. So I appreciate the cooperative work that was accomplished by members during this last constituency week. So I see no other speakers. So is there a consensus to adopt the sub-amendment by Mr. Garon with the understanding that the amendment will be submitted? So Mr. Garon's sub-amendment is adopted. Thank you very much, colleagues. And so we're now back to CPC 7 as amended, and I'll recognize MP Perkins.
Thank you, Mr. Chair, and thank you, colleagues. As a follow-up to what MP Turnbull and I just said, and thank you, Monsieur Guérin, for your, I would like to propose another amendment to CPC 7, which was originally proposed by Mr. Viss. So I will read with the, and it's been circulated, but I'll read it with the additional words that we've just passed in a minute. So just to remind those who may be watching, we're dealing with the definition section of the bill, and we're adding the definition for the word sensitive. So it says sensitive in relation to information includes any information about an individual for which the individual generally has a high expectation of privacy, which, and then we add the word may, and then we change the word includes to include, so which may include, but is not limited to, all the following, that's already in the motion, A, B, C, D, E, and then F changes the word security, since that's not a Canadian term, social insurance, so substitutes insurance for security. G deletes the word or, H deletes the word or, and adds a new I, as we discussed, I think, in our last meeting, I being geolocation data revealing an individual's location, brackets, de nature sensible. Close. My French lessons, I'm still working on it. So I'll leave that as moved, and I will say that in the break we had a consultation with the current and past privacy commissioners, and they're both comfortable with it.
Parfait. Peut-être juste d'emblée.
Maybe to start with, there's a bit of an issue with the French version.
Yeah, well, I'm sorry to say it shows no harm, no pun intended, but so en matière de protection de la vie privée, lesquels peuvent comprendre.
So in the French version, I think we'd have to we'd remove qui comprend. We'd have to remove that in the French version. That is more, that will be more reflective of the English version.
So if you look at the French version, si vous regardez, Monsieur Viss, la version française.
So if you look at the French version, it says high expectation of privacy, and then in the French, lesquels peuvent comprendre, and then the version that Mr. Perkin is proposing continues on to say qui comprend notamment et sans limite. So it's repetitive. That doesn't make sense. So we would just take out the words qui comprend. I see that Mr. Garon and Mr. Généreux both seem to agree, and at the end as well. And yes, and then there is a missing or after H in the French version. So the last phrase is kind of worded bizarrely in French, and I'm looking at you, Mr. So there's wording changes. L'individu would that be better in French? But so the two previous changes, I think we need to add the ou, which is or in French, but I'll leave it up to you. So did everybody hear the sub-amendment proposed by Mr. Perkins?
my headset. I was looking for a
Okay.
headset.
Are there any comments? Are there any comments on the amendment proposed by Mr. Perkins? And everyone's heard the amendment. So is there consensus to amend it, to adopt it? Monsieur Massey?
Yeah, no,
Mr. Massey?
brief description from the officials on this for the record, because we got lobbied heavily on this, and perhaps a little bit better of an explanation of changing it might be worthwhile. So even for the record, if that's possible.
Sure thing.
So my question would be, basically, can you update the public in terms of what this means in terms of the amendment that's been changed and presented in, especially describing the may, I think is probably the most germane with that.
Thank you for the question, Mr. Chair. I understand that the modifications being proposed to this sub-amendment would add to the definition of sensitive information. Sensitive in relation to information includes any information about an individual for which the individual generally has a high expectation of privacy, which may include but is not limited to, and then provides the list from items A to I. Our interpretation of this is that it provides directional guidance to the Office of the Privacy Commissioner about information that would generally be considered sensitive, but leaves open the possibility for the Privacy Commissioner to identify on a contextual basis information that could be sensitive in a different context that that the committee may not have identified on this list. It also leaves open the possibility that some of these categories of information, in accordance with, for example, the Supreme Court decision that we briefed to this committee some weeks ago, RBC versus Trang, would leave open opportunities for the OPC to provide a contextual analysis, for courts to undertake a contextual analysis that would determine that in some instance, for example, likely rarest instances, things like financial data may not be sensitive. That would be the ultimate effect as we read it.
And that kind of then deals with the concern that's being expressed is that, I forget the term that they use, but fatigue or something like that was used in terms of consent fatigue. Yeah, yeah. So I want to thank the mover of the, first of all, the block and then the Conservatives there for, and I guess the government too, everybody getting to this, because it provides the Privacy Commissioner with some empowerment when necessary. But at the same time, we get to that issue, which a lot of people raise as concerns.
Thank you very much, Mr. Massey. Mr. Viss?
Just following up on that exchange, did the department meet with the Canadian Bankers Association in advance of the 2 letters we received?
Thank you for the question. I believe we may have received an email from the Canadian Bankers Association. There may have been dialogues at various points as well. I don't know the timing of the meetings compared to when the letters that you're referring to.
I was referring to the May 7th letter sent to the Industry Committee.
No, there was no meeting on that date.
Thank you.
Okay, thank you very much, colleagues. So is there consensus to adopt the sub-amendment?
Vote just to make sure, since there's been so much debate.
That's just the sub-amendment, not the
On the full
CPC
one,
7.
yeah.
So for the sub-amendment proposed by Mr. Perkins, is there consensus to adopt it?
Sure.
Okay, so it's adopted. So we're back to CPC 7 as amended. Now perhaps we could call for well, are there comments, or we'll call for a recorded vote on CPC 7 as amended.
Mr. Turnbull,
We,
Mr. Gahir,
In favor?
Mr. Chen,
NDP
In favor?
Mr. Sorbera,
Yes, please.
Mr. Van Bynen, Mr. Genereux,
Wait.
Mr. Perkins,
Yes.
Mr. Viss,
Yes.
Mr. Williams,
Oui.
Mr. Garon,
En faveur?
Mr. Massey.
CPC 7 is adopted. Thank you, colleagues. It's been, yeah, congratulations. And so this would take us to, and I had on my list NDP 6, but I'm guessing Mr. Massey won't be moved.
That's right, Mr. Chair. It's no longer necessary. Thank you.
Which takes us all the way to CPC 8. Mr. Perkins.
Thank you, Mr. Chair. The Consumer Privacy Protection Act makes reference to the term significant impact on several occasions. And we are concerned that the CPPA does not currently explicitly include a definition of what this term means. And given the significance of this term throughout the bill, it poses considerable issues in the face of conflicting interpretations and views of what this term constitutes to stakeholders and businesses. So significant impact is currently featured twice in the bill, in section 62(2)(c), where it states policies and practices of openness and transparency, an organization must make general account of the organization's use of any automated decision system to make predictions that could have a significant impact on them. That goes on to say this section concerns how an organization must make available any policies or practices put in place to fulfill it. Then section 63(3), access to personal information concerning the use of automated decision systems, it makes another reference, and if the organization has used an automated decision-making system with regard to an individual that could have a significant impact on them, they must, on request, provide an explanation to the individual. This section concerns an organization's requirement on request to fully inform an individual any use of personal information and provide access to that information. In the same way that automated decision system is defined in the CPPA to explicitly explain and outline the use of certain technologies, the impact of these technologies should be explicitly defined in this bill to remove any ambiguity and protect Canadians. The consequences of not including the definition of significant impact present a threat to the compliance of personal information and protection. And we've worded it in a way that says prescribed criteria, which I believe allows flexibility for policies and perhaps even regulations to be drawn up after the bill's passed in this area. But I would ask for, if I could, Mr. Chair, officials to comment.
Yeah, thank you very much for the question. We would agree that as defined here, significant impact means an impact that meets the prescribed criteria. The government would need to undertake a regulatory process following this to set those criteria.
Est-ce qu'il y a des commentaires par rapport à l'amendement?
Are there any comments on this CPC 8 amendment? Madam Clerk, do we need to go to the vote? Okay, we'll go with a vote.
Mr. Turnbull,
In favor.
Mr. Kahir,
In favor?
Mr. Chen,
In favor?
Mr. Sorbera,
In favor?
Mr. Van Bynen. Mr. Généreux,
En faveur?
Mr. Perkins,
Pour.
Mr. Viss,
In favor?
Mr. Williams,
En favor?
Mr. Garon,
En faveur?
Mr. Massey. Carries.
L'amendement CPC 8 est adopté. Merci à tous.
It's been adopted. Thank you, everyone. That brings us to CPC 9. And just so you know, if this amendment is adopted, the NPD 32, 38, CPC 7D will not be able to be proposed, and NDP 37 will not be able to be proposed as well because of a line conflict and a lack of consistency, if that's the case. So just so that you know. Mr. William, the floor is yours.
And as you noted, this is a rather wide-ranging amendment, making changes in numerous sections and subsections through the CPPA. And its purpose is to transfer power to issue monetary penalties for violations in the CPPA from the Privacy Tribunal to the Privacy Commissioner, where we in the Conservative Party believe the power should be rested and where it should have been rested in the first place. We are of the opinion that the tribunal is completely unnecessary and counterproductive. It will make Canada an international outlier compared to how our peer nations operate. is unneeded bureaucracy which will only serve to slow down and dilute resolutions of privacy violations. It will hamper the ability of the federal and provincial privacy commissioners to work together and perform joint investigations. And most concerningly, by existing within ISED, the members who are patronage appointees by the minister, the tribunal is an attempt to impede and interfere with the independence and jurisdiction of an independent officer of Parliament. The proposed tribunal will make Canada an international outlier. No other peer nation, not the EU, not the US or the UK, Australia, or any other G7 nation has a privacy tribunal. Each of these other nations has the same system. The privacy regulator investigates and issues monetary penalties to violators. If the violator is unhappy with the result, they take the regulator to court. We know this because that is the way our privacy enforcement system currently operates. The Privacy Commissioner, PIPEDA, and the Privacy Act do not have a tribunal, and the enforcement process is working quite well. According to the Office of the Privacy Commissioner, for more than 40 years, this is how the process has worked, and only once in the 40-year period have the courts taken issue with an OPC ruling. There is no need to reinvent the wheel by introducing a quasi-judicial body into the violation enforcement process. By trying to reinvent the wheel with this tribunal, the result will be delayed justice for Canadians whose fundamental right to privacy has been violated. Justice delayed is justice denied. When I think about the quasi-judicial tribunals of the ISED, of course, my thoughts immediately go to the equally unnecessary Competition Tribunal. It's a body which has never been, in its nearly 40-year existence, has never blocked a merger, even ones proven to be anti-competitive by the Competition Bureau. It's a body where the average time for delivering a decision is well over 1 year, except, surprisingly, the Roger Shaw decision. Even then, those decisions can be appealed in the courts. The tribunal also served to drag out the efficient resolution of cases. I will let the words of the Privacy Commissioner stand for themselves, who stated that the fourth and probably most important, the fact that the OPC would not be authorized to impose administrative penalties and that its orders would be subject to appeal to another administrative structure before reaching the courts would reduce the incentive organizations have under the model in place in other jurisdictions to come to a quick agreement with the regulator. In these jurisdictions where the Data Protection Authority is the final administrative adjudicator and where it can impose financial penalties, organizations have the interest in coming to a negotiated settlement when during an investigation it appears likely a violation will be found and a penalty may be imposed. Unfortunately, the creation of a tribunal would likely incentivize organizations to play things out through the judicial process rather than seek a negotiated settlement with the OPC, thus depriving consumers of quick and effective remedies. Sadly, but truly, justice delayed is justice denied. The inclusion of the tribunal in this act is argued by both federal and provincial privacy commissioners will also weaken the joint investigation processes that are undertaken between federal and provincial governments. This process will also diminish interoperability between provinces and could result in the federal government making the Privacy Tribunal a necessary requirement for compliance within the Federal Act. We've seen several recent examples of the federal and provincial policy commissioners working together to protect Canadians' fundamental privacy rights. In 2021, the federal commissioner, along with BC, Alberta, and Quebec, all worked together to investigate and stop Clearview AI from violating Canadians' privacy rights through illegal scraping of images from social media sites to build a facial recognition database. In 2022, federal, Alberta, BC, and Quebec commissioners again worked together to investigate and stop Tim Hortons illegally tracking Canadians' location data after they made a purchase. And in 2020, the federal, Alberta, and BC commissioner stopped shopping mall owner Cadillac Fairview from collecting and using photos of consumers when they had stopped to use the store's directory screens. We have heard and talked a great deal so far during this clause-by-clause process of making sure that privacy protection laws are consistent across the country to allow ease of enforcement as well as ease of business operation. As we heard from both federal and provincial privacy commissioners, that tribunal will threaten the ease of enforcement by regulators across each of the provinces and territories and across the country. The Privacy Commissioner in their office is one of 10 fully independent officers of Parliament. In the words of the Library of Parliament, officers of Parliament support both houses of their accountability and scrutiny functions by carrying out independent oversight responsibilities assigned to them by statute. These officers are responsible directly to Parliament rather than to the government or a federal minister. I want to emphasize that last line, responsible directly to Parliament rather than the government or a federal minister. The Minister of Industry should not have a say over the conduct of the decisions of the Privacy Commissioner. The OPC is supposed to be fully independent. If the Minister or government does not like a decision of the Privacy Commissioner, then they can appeal the decision in the courts, as they have done since the OPC was created in 1977. The proposed tribunal will completely undermine that independence. It places an ISED-run, ISED-controlled, ISED-funded, and Minister of Industry-appointed privacy tribunal in between every single OPC ruling and decision. The Office of the Privacy Commissioner is an independent body, and this amendment will help to preserve that independence. Mr. Chair, through you, my question, through any of the officials want to answer, but Mr. Chabra, we know from submissions and testimony that the current and former Privacy Commissioner opposed the tribunal. The provincial privacy commissioners oppose the tribunal, and almost all privacy advocates and experts oppose the tribunal. Your department has been the ones asking and taking ministers with stakeholders, the minister's famous 300-plus meetings. Which stakeholders have actively been supportive of the tribunal?
Thank you very much, Mr. Chair, for the question. As pointed out, CPC 9 is a very broad set of proposed amendments that would, as we understand it, have the effect of doing three important changes. First, it would limit the imposition of cost awards against the OPC. Second, it appears to remove the private right of action that would allow folks who've been impacted by a transgression of law to be compensated for their loss. And third, it would remove the tribunal from the Part 1 of the Act. We see the tribunal as a critical element that's necessary to ensure that the system is credible and fair. Removing it would be inconsistent with the current commissioner's recommendations. We have, since 2018, conducted a significant number of consultations and engagements, broadly engaging Canadians. I believe in 2018, there was more than 30 roundtables across the country. More than 550 Canadians participated in those engagements. The more recent figure of 300 meetings that the honourable member referenced, I believe, refers to Part 3 of the bill on ADA, which we will obviously come back to later. A number of stakeholders pointed out that it would be perhaps unprecedented and certainly out of alignment with international examples and even some domestic models and examples to have one individual carry out an ombuds function, an investigatory function, and an adjudicative function all in one. There have been, to our count, 50 cases since 2003 that have gone to court from Privacy Commissioner and on to court. By our count, 70% of those court decisions disagreed with the OPC's position on the issue. Expecting the Privacy Commissioner to carry out these very distinct functions, in addition to the significant new powers that have been added, the CPPA is going to provide the Privacy Commissioner with a number of new enforcement powers. They include the ability to issue binding orders following investigations, which can order compliance with the CPPA. They can order organizations to cease activities that violate the CPPA. They can force the compliance into a compliance agreement and also make public any measure taken to comply with the CPPA. In addition, the CPPA enables the Commissioner to recommend monetary penalties, administrative monetary penalties. And that's the point at which a recommendation would be made to the tribunal around the penalties. The orders and all of those are powers that are being vested directly with the Commissioner and not with the tribunal. And it's important to recognize as well that the tribunal has an important appeal function to play and has expertise in the space by virtue of the fact that 3 of the 6 members of the tribunal must be recognized as privacy experts. I also think it's important to point out that we don't see any risk of, hampering joint investigations that would be undertaken between the federal Privacy Commissioner and any provincial counterparts. A number of international counterparts do have tribunal-type approaches. Australia, New Zealand, Ireland, off the top of my mind. The UK also has a tribunal approach organized slightly differently. The CIE on Quebec also has a tribunal approach to doing this function. And so we don't see any issues around joint investigations at all. In fact, CPPA specifically encourages and allows for the OPC to engage with other regulators to share information and to leverage that information to the best effect to protect Canadians. And it's also consistent with other areas of federal regulation where tribunals are used in agriculture, transport, competition, and international trade. The efficiency of the CPPA tribunal has also been raised in this recent kind of dialogue, and it's important to recognize that we see efficiency gains actually being made by providing a tribunal that, first of all, pays deference to the commissioner's decisions, whereas a court would take a de novo proceeding, by having proceedings that are more informal and easier to understand and engage with for ordinary Canadians rather than having to have a lawyer go through the proceedings with the federal court. It would be less costly and easier to access as well for those reasons for ordinary Canadians to engage with. There are a number of very important reasons why we feel the tribunal is the right approach. The department did receive many inputs to that effect from a range of stakeholders ranging back to 2018 before the previous Bill C-11 was introduced. I hope that helps to answer the question.
Thanks. I just want a little more specifics. Can you give me a couple examples of who suggested the tribunal for stakeholders? And did you meet with them?
You want to take on this?
So we published the department published a white paper in 2019 on proposals where we specifically asked questions on the tribunal and whether the privacy commissioner should be given AMP powers and whether those AMP powers need an oversight mechanism. And to that, we received a number of responses from industry, from privacy stakeholders, from the privacy commissioner himself. And I'm just going to pull up a list.
And so I'm just going to get Mr. Chamber to correct yourself. You did mention that the current privacy commissioner recommended it. We can't find that recommendation. We have that the current privacy commissioner does not recommend a tribunal right now, correct?
So the current privacy commissioner has two recommendations with respect to the tribunal. They've asked that the tribunal's decisions be reviewed by the Federal Court of Appeal as opposed to the federal court, and they've asked for more flexibility with respect to compliance agreements. So those are the two recommendations from the current privacy commissioner.
From what we understood, it was also if a tribunal were to be in place, but their preference would be not to have a tribunal, more power to the privacy commissioner themselves in their office. Just to counter one other claim as well, they've asked for more, and they said they need more resources to carry out the duties they'd have. So to handle the burden that you mentioned, there would be a whole division that handles the fines and the penalties, and then the commissioner would be freed up to be able to handle more of a caseload. I think that was what was stated from testimony. I'm just going to mention two witnesses that were against the tribunal, because we do have a list of those. If you're looking still for the list that were for it, we had the Center of Digital Rights, the Privacy Commissioner of Alberta was against the tribunal, the Operation Consommateurs was against it, the former UK Privacy Commissioner was against it, the UKSA, the Public Interest Advocacy Centre were against it, the Canadian Civil Liberties Association was against the tribunal, the Privacy and Access Canada was against it, University of Ottawa, McInnes Cooper, a lawyer, David Fraser was against it. Danielle Therian, the former privacy commissioner, was against our tribunal. Philip Dufresne, the privacy commissioner of Canada, was against the tribunal as a whole. These are all witnesses that we had while you're looking for your list of ones that supported it who were against that tribunal. Have you found your list?
So I do have the list of the testimony of witnesses that did support the tribunal. There was Elizabeth Denham, the former UK Information Commissioner, also the former BC Commissioner, who spoke about the UK tribunal system and how they aid the process and ensure administrative fairness. We also had Adam Kardash that supported the tribunal. He's a lawyer with Canon, which is the Canadian Anonymization Network. Michael Geist also suggested that the tribunal does is granted some deference when it goes to court. So that has the potential to strengthen the outcomes of the process. Mr. Scott Lamb, partner at Clark Wilson LLP, also supported the tribunal, as did Mr. Antoine Guimont and Ms. Michelle Gordon. So those are the witnesses during the committee hearings that supported the tribunal.
Okay, and I think I'm looking for testimony now from the current privacy commissioner, because I just want to, I know that was mentioned at the beginning, but Mr. Viss was going back and forth with Mr. Dufresne, and Mr. Viss asked, is it your belief that a tribunal will delay your ability or the ability of people to have sensitive information away from the internet? Mr. Dufresne answered, my view is that adding a level of review to the process will add a delay and a cost, so I've given two options to solve that. And the other part that he mentioned was, there remains a proposed additional new tribunal, which would become a fourth layer of review. And the complaints process is indicated in our submission of the committee. This would make the process longer and more expensive than the common models used internationally and in the provinces. So he's basically, and I think from former commissioners we saw, they've added the burden of this. I want to go down to another line of questioning with you, and it goes to,
I got Elizabeth Denham's too.
oh, sorry, I'm going to add.
It's contradictory to what she said.
Okay, and this is Elizabeth Denham. You mentioned the UK Privacy Commissioner, but this is her testimony. From the top, she said, my last point is that the Bill C-27 creates a tribunal that would review recommendations to the Privacy Commissioner, such as the amount of an administration fine, and it inserts a new administrative layer between the Commissioner and the courts. It limits the independence and the order-making powers of the Commissioner. So you mentioned that the Elizabeth Denham was supportive of the tribunal. This testimony seems that she was against the tribunal.
I think a number of pieces there, Mr. Chair, that I'd like to try to unpack. I think in the context of order-making powers, we've already been clear that the order-making powers in the CPPA would vest with the commissioner. So it's difficult to see how the tribunal would be slowing down the order-making abilities of the commissioner. The notes that we have here from Ms. Denham include that there is a tribunal system in the UK, that administrative tribunals are used across many areas of law. It may seem like a lengthy process, but over time, the tribunals become expert tribunals, and the C-27 proposals are aimed at ensuring administrative fairness. And that is really what we're talking about here, is the carriage of justice, about administrative fairness, and about ensuring that there is an appropriate delineation of powers and responsibilities. Do you want to jump in with details? Good. My colleague will take a moment as well.
Sure, and I just want to jump in on the current commissioner's assertion that the tribunal would add a fourth layer in the process, and I think it's important to understand the process now and how the tribunal would change it. So the process now is the privacy commissioner is an ombudsperson. It actually it has investigative powers, but has no decision-making powers. So what happens is the commissioner issues some findings. Those findings, a company can choose to undertake those recommendations based on the findings or not. And if they do not, the commissioner's only option is to take that company to court. When they take that company to court, the court gives the commissioner no deference. It's like any plaintiff taking a company to court, they have to make their case. And as my colleague suggested, in many times the commissioner loses those cases. Most recently in 2023 against Facebook. And then obviously you can appeal that decision to the Federal Court of Appeal and eventually to the Supreme Court. So that's the current process. What this new process is going to do is, first of all, it gives the commissioner decision-making powers. The commissioner can issue compliance orders, which is something that it can't do, which actually compels an organization to do or not do something, and can recommend apps. Those decisions can be appealed to the tribunal. But once the tribunal makes a decision, actually before that, the tribunal has to actually grant the OPC a lot of deference on questions of fact and questions of law. So that's the first difference with a court, which wouldn't do that. The second difference is once the tribunal makes that decision, the decision is final. The decision cannot be appealed. The only recourse possible is a judicial review. A judicial review is not the same thing as an appeal. An appeal is a substantive reconsideration of the merits of a case. A judicial review is simply a court, and in this case it would be the federal court, would just decide on whether the tribunal acted reasonably or not. It's not a substantive reconsideration of the case, and hence is not an appeal. So the tribunal's decision is final. What that means is that it's a shorter process, it's a quicker process, it's a less expensive process.
And just to add to that, on the point of compliance orders, the current privacy commissioner did point out a concern about his ability to enter into compliance agreements that would include financial considerations. And that has been adjusted by a proposed amendment as well to give the ability for the privacy commissioner to enter into a compliance agreement at any stage of the process and to include financial considerations in that. So we feel that the commissioner's perspectives on this have been well understood and taken on board.
We had one witness, Jim Basili from the Center of Digital Rights, talk about it from a business perspective and talked about the other layer. And he said, you know, what's going to happen is if you're a corporation trying to negotiate with the commissioner, you'll just shrug your shoulders and say, well, I'll see you at the tribunal, which is quasi-judicial. You know, we've seen some of this with the Competition Bureau. When we look at the Roger Shaw case, it was so bad that when the tribunal made a ruling opposed from Competition Commissioner, then that company was able to then sue the commissioners themselves. It created another layer. It created a precedence that we don't want to see happen with our privacy laws. I think I'd like to go down to this other question as well. You know, there's no other privacy law regime in the world that has this tribunal. So, you know, we're looking at progressive regimes in the EU as well as regimes in California, Utah, Colorado, Virginia, and Connecticut. And the proposed American Data Privacy and Protection Act, no one has proposed or established a tribunal like the tribunal being proposed. So why is Canada trying to be an outlier? For what benefit?
Thank you again for the question, Mr. Chair. I think it's a really important one, and I appreciate where the committee members are coming from in terms of identifying good practices, opportunities to bring into Canadian practice, things that have worked well in other jurisdictions. But I also think it's really important to make distinctions about the way the various systems work. We cannot holus bolus import various pieces without understanding the context and the way that they're developed. I believe the honorable member just mentioned California. California does not have a consent-based system. California has an entirely different establishment where people essentially can opt out of having their data collected, but in a way that is completely different than actually having to seek consent and have that as the cornerstone of your approach. The reason I raise that is because understanding the way that these legal frameworks work in their totality is really critical to understanding which pieces could simply be added or extracted to a given mix and would make sense and be coherent within that legal framework and then within the Constitution or other broader legal frameworks in a given jurisdiction. In this instance, we have seen tribunals be effectively deployed in privacy in the UK, in Quebec, particularly very closely aligned with the approach we're suggesting here would be Australia, New Zealand, and Ireland. There are considerations in Canadian law that suggest that it would be appropriate, that Canadians expect to see procedural fairness, that they have an expectation that there will not be a single judge, jury, and executioner, but rather that there will be an approach that allows for the investigative function to take place in a way that's unfettered, that allows for joint work, that allows for alignment, collaboration, but simply that the imposition of monetary penalties be done in a way that is an expert body that can focus on determining on the basis of the investigation, as my colleague Ms. Angus pointed out, with deference to the commissioner's approach, be able to take those decisions. The second point that I think my colleague already elaborated on very effectively is about when it comes to an appeal, the the tribunal would have to give deference to the fact-finding and investigative results of the commissioner, which is actually a much improved situation for the commissioner and makes a much more streamlined and speedy process to land on a final outcome. I think if there were situations in which participants engaged in a scenario that the privacy commissioner is investigating disagree with the privacy commissioner, I think most Canadians would expect that there would be a recourse or an appeal or a place to go and have that be adjudicated effectively by a body that has expertise in privacy, particularly as we increasingly encounter digital issues, digital market issues, privacy issues that can be quite complex to understand and perhaps beyond what a layperson would ordinarily experience. Having a body that is developing expertise in this space and is able to grow with the digital economy, I think is a very core element of why it's a useful piece to have.
Why have we not maybe looked at the Quebec model? In Quebec, the Commission to Access the Information to Quebec can directly impose administrative monetary penalties. Recently, a new bill was passed in Quebec that enables the Office de la Protection de Commercier to impose administrative monetary penalties directly as well. Why did the federal government not look at what's being done in Quebec?
So the Quebec model is really very aligned with the model we're proposing. The main difference is that the tribunal is built into the CAE. So the act for the CAE establishes several sections that have very clear purposes. There's une section de surveillance, une section juridictionnelle.
A section of surveillance and
that's actually supported by 8 administrative judges that act as an appeal mechanism within that. So a case can come from the jurisdictional side for an AMP, and that is appealed, and it's the administrative judges that support the president's office that actually can review that decision. So it's actually a tribunal that's built into the organization. So what we are proposing is very much aligned with that model, except that there is a structural separation between the two bodies that perform those functions.
And as you noted, the current system right now, which would be then appealed just to the federal court, to the, it's not the federal court.
At this time, there isn't an appeal because the OPC doesn't have any decision adjudicative powers, so it's a de novo proceeding.
But in terms of the powers of the commissioner, which would be the issue orders and administrative monetary policy, up to $10 million at 3% of sales, those powers will be in effect, no?
I'm sorry, I'm not sure. You're saying they would be in effect under CPPA?
So the minister, the commissioner will have those powers to have to issue orders. The tribunal then would be able, you're saying right now is the only way to have recourse. If we take the tribunal away, there would be no recourse to the courts? Is that what you're saying?
Depending on the decisions that this committee makes and how it's structured, I think there'd be some potential challenges in terms of the implementability of CPC 9 as it's structured now, including with regard to Part 2 of the Act. I think there would probably need to be several, we would need to take some time to go through it again and see what I think what you're asking is what would the default be if the tribunal is removed? I think that there's both principled issues as well as implementation issues that could arise. So on the principles point, there's principle of kind of natural justice and administrative fairness that I think needs to be managed. I think you could still imagine a scenario in which it would move through the federal courts and the Court of Appeal and the Supreme Court, which is kind of what we mentioned earlier. You would end up in a situation that is analogous to today roughly, and that the decisions could be appealed. Each appeal would be a de novo proceeding. Each appeal would have to review the basis of fact to begin. That is going to be a more lengthy and drawn out and more challenging process than the one that would be undertaken under a tribunal system.
Okay, so I'm going to let this go into more discussion from other members, Mr. Chair. But I think what I'm understanding is we'd have to relook at Section 2. Well, I think that's the whole point of this amendment, is that Section 2 is about a tribunal. we're looking at, and a lot of what we do from our side is listening to the witnesses, but specifically the current privacy commissioner and the former privacy commissioners when they're looking at the system and how it operates and how they'd like it to operate. More importantly, when we look at protecting Canadians' consumer rights as a fundamental human right for privacy, looking at a system that looks at best practices across the world, not just reinventing the wheel, and specifically from our side, looking at what's happened from the tribunal and the competition commissioner's aspect and how it hasn't worked or perhaps hasn't been working as well as we'd like it to. I'm going to leave it, Mr. Chair, that I still feel that the tribunal is unnecessary. I think we can go through better aspects to improve that process on the appeal system and the powers, and of course, giving more power to the offices of the privacy commissioner. And I'll leave it at that. Thank you, Mr. Chair.
Thank you, Mr. Williams. So I have Mr. Massé, Mr. Viss, Mr. Turnbull, Mr. Garon, and Mr. Perkins.
Thank
Mr.
you,
Massé.
thank you, Mr. Chair. I'd like to draw a picture, I guess, in terms of for people that following this, how the tribunal, how many members would be part of the tribunal?
Thanks very much for the question. It's proposed to have 6 members, 3 of which would have to have experience in information and privacy law. I think it's also worth pointing out that the proposed approach is to have them be appointed by the governor and council. They would not be ministerial appointees under the proposed act.
Okay, and so what would happen though, say for example, the tribunal split 3-3?
What's the tiebreak?
Yeah, no worries. All good.
There's a tiebreak procedure. I just want to make sure I'm getting it
Yeah,
right.
yeah. No,
before I
because
respond.
I'm just trying to paint the practical process here for people that
Understood.
are. Yeah.
Sorry about that.
No, that's okay. It's a pretty big bill.
If you have another question, maybe we could come back to that one if that's all right.
Yeah. So would these be like full-time positions? What's the compensation? Get an idea of how this even works. I mean, I think that one of the concerns that I have is that this also becomes a political appointee process that maybe doesn't have the right trust, or it can be influenced by industry. Those are, I think, legitimate questions. I mean, I question some of the large
Do you want to respond?
companies that were here.
Right. Okay. So the point is it's 3 to 6 members, not 6 members firms. Apologies for that. But,
Okay. Yep.
3 of which have to have the expertise and experience in information and privacy law as a background. I have to get back to you on the question about the tie break, but they would be full-time positions. Full-time or part-time. Yeah. Okay, full-time or part-time. So I think it's going to depend on the degree of volume that's moving through the tribunal system.
Okay. So it was interesting because here's what part of my concern is that my private members bill, I'm going to use this as an example, that's in the Senate right now. Parks Canada has this policy that they're putting, and they best describe their own policy as we're trying to build, paint, and fly the plane at the same time. I guess what I'm worried about with this tribunal, if it's the same type of a process, that if, perhaps in the future, if there was the will or requirement, we could add the tribunal back in the future for another parliament if the system didn't work very well for the for the privacy commissioner.
So just to make sure I understand the question, Mr. Chair, it's about could the tribunal be added to the system after the fact?
Yes. I know it's a hypothetical, and again, we can do anything really. I mean, at the end of the day, I mean, it's just a matter of legislating it like a change.
I think the implementation question that would be most present, I think, before the committee is whether the tribunal could, or whether the other important aspects of CPPA could be advanced in their current form without having the tribunal there, as it's currently built into a number of different portions of the Act. As you see, the effect of CPC 9 is actually very broad and throughout kind of Part 1 of the Act. I think it would be important to consider alternative mechanisms to achieve the policy intent that the tribunal would play in a number of different zones across the proposed amendment. And so answering your question in the hypothetical about whether a tribunal could be added downstream is a little bit challenging because we would need to look at each and every instance in the bill where the tribunal is currently playing a role and ask, are there alternative approaches that could be developed instead? So I think that's the implementation challenge that the committee would face now.
Yeah, no, that's fair. I mean, I don't want it to appear that it's an easy thing to do later on. That's definitely not the case. It would require, and this is what I'm struggling with, is whether or not introducing this is necessary at the time. And so I'll turn it to other colleagues to ask questions, but that's kind of what I'm wondering at this point in time.
Merci, Monsieur Vice.
So I'm just going to this is a very important discussion, and I will admit there was testimony received on very strong testimony received on both sides of the tribunal. If I'm to understand it correctly, there is right now the privacy commissioner has investigative powers. Those investigative powers would obviously still be retained if Bill C-27 is passed. The privacy commissioner, I'm speaking hypothetically here, conducts an investigation and recommends, if this bill passes in its current form, the privacy commissioner will recommend to the tribunal to an administrative fine for a breach of privacy. Then the tribunal will have to decide. Am I correct so far? No, please correct me.
Thank you, Mr. Chair, for the question. So in the proposed model under CPPA, an investigation would take place
By the privacy commissioner.
by the privacy commissioner, exactly. The privacy commissioner would have the ability to enter into a compliance agreement that would have, there are numbers of outcomes that could happen. The privacy commissioner could issue an order that says, I'm ordering this company to cease or desist a certain behavior, or I'm ordering this company to take this remedial action to improve its privacy management program and its practices. It could enter into a compliance agreement where those requirements are featured and a financial discharge is also included. All of those things are possible and within the privacy commissioner's remit without the tribunal.
Right. But in the cases where the tribunal is involved.
So the case the tribunal would be involved would be one where the privacy commissioner has gone through the entire process, may or may not have issued orders, and then wants to recommend that an administrative or monetary penalty be applied.
Yeah.
And that he or she would then recommend to the tribunal on the basis of facts of the case,
Yes.
the investigation, and here's the AMP that would be recommended. And the
Right.
tribunal would specialize in narrowing down and deciding on the level of the administrative monetary penalty on the basis of the facts of the case as presented.
Would the tribunal be commencing a de novo study of the issue at hand? Or would it be solely based off the findings from the investigation conducted by the privacy commissioner?
In a case where the privacy commissioner is recommending an administrative monetary penalty, it would not be a de novo consideration by the tribunal. It would be about taking the facts of the case and identifying the right level of administrative monetary penalty. There is another point that I think is really important to understand here procedurally, which is that the privacy commissioner could go through the process, develop, for example, an order to say, I'm asking this company to cease and desist this behavior, or I'm asking them to adjust their privacy management plan to change the governance structure, for example. If there were an appeal of that decision, the tribunal would hear that appeal. And again, it would not be hearing it as a de novo proceeding. They would have to give deference to the findings of the commissioner. So it would not be relitigating the entirety of the findings or the investigation, but reviewing it in a more narrow approach, as compared to if there were not a tribunal and a federal court would have to take it on, it would be a different proceeding.
I'll stop there for right now. Thank you, Mr. Chair.
Merci beaucoup, Monsieur Turnbull.
Thanks. Happy to get into this debate. So I wanted to challenge the claim that Mr. Williams made in his remarks, which was, I think, solely based on an argument that's claiming that the tribunal would slow things down and add bureaucracy and make things less efficient the way I'm reading it, and even just what you responded to Mr. Viss, suggests to me that deference literally means that the evidence that was the result of an investigation by the OPC would be considered within the tribunal's work, whether it was an appeal or whether it was determining the right volume of an administrative monetary penalty. So could you unpack that for us? Like, how is this? Because I get the claim, I get the perspective that the Conservatives and some others are bringing up here. I get it. We don't want to add bureaucracy and slow things down. That is not the intention. My understanding is the tribunal would actually speed things up. And I'll get to this after with a separate question, but I want to ask you about trust and administrative fairness and unpack that more. But let's just start with efficiency and eliminating bureaucracy, if you could unpack that for us.
Thank you, Mr. Chair, for the question. We believe that having a tribunal in place will increase speed and efficiency of the process. The tribunal, unlike a court, is going to be required to give deference to the commissioner's decision. I think that's the important first piece to understand. What that means is that the tribunal does not need to start all over again or de novo when reviewing a file. It can consider and adopt the work and the reasoning that the commissioner has already done. And that allows for a more streamlined and efficient process to move forward. And most importantly, the tribunal's decisions itself will be considered final. That means it's not something that can be appealed to a higher level court. Somebody could seek a judicial review of the decision, but a judicial review of a decision is far narrower. It does not reopen the findings of the case. It's about determining whether the decision of the administrative body was fair, reasonable, and lawful. Generally speaking, what that means is that the court is being asked to review whether the tribunal acted within its authority or mandate. That is an entirely different scenario than going through an appeals process to various courts and relitigating and reopening the case at each stage and having new facts to bring to bear. So in that way, it would be expected to be resolved far more efficiently and sooner than if you were going through an appeals process.
Thank you for that. I also understand that one of the other benefits of a tribunal would be the expertise of the individuals that are a part of that tribunal process. Can you speak to how, if you look at two possibilities, one where the tribunal is in place and one where there is no tribunal, and one has to go through the federal court system, how would that affect the timelines and perhaps the trust in, I have in my notes, and I think you referenced it, Mr. Chabra, about a case with Facebook where the OPC was deemed to maybe not have had enough evidence or the quality of evidence. You can correct me if I'm wrong, but I just wonder how important is it to not only procedural fairness, but also to, I think, a speedy process to have people with specific expertise in privacy.
Thank you again for the question. I think we've seen that these issues tend to be quite complex when it comes to personal information, data flows, how information is being utilized. It is not necessarily a straightforward proceedings, and it's not necessarily one where a judge would typically have a significant amount of experience in previous case law to build from. There is some, obviously, case law in this space, but not to the level that might be considered a commonly understood approach. The speed element comes from both making sure that the tribunal's decisions themselves are considered final so that they're not being appealed, but also the degree of expertise resident in the tribunal is specifically designed to respond to stakeholder feedback that was received before C-27 was tabled about the importance of having at least 3 members of that group having expertise in privacy and information law, which is a growing field of law where experts have been developing their kind of understanding of the issues and also understanding how emerging issues in digital technology space in terms of how data is being used how those could have important effects on individual privacy. So understanding the nexus of cybersecurity, understanding the nexus with de-identification or anonymization techniques, understanding the importance of kind of governance approaches taken within organizations, understanding the approaches being taken in other jurisdictions as well. There are a number of reasons why having expertise in the domain of privacy law and privacy and information protection would be helpful to speed and make the decisions more effective and procedurally fair.
Okay, let me back up for a second and ask you something. So thank you for those clarifications. I think your comments have helped me understand how specifically the tribunal would make the process more efficient, not more bureaucratic and laden with. So, and I wonder, I mean, this is maybe going back and then I'll go forward, but do we know exactly how in other jurisdictions where a tribunal is in place, how much more quickly things can move through a process of appeal, for example? Do we have any kind of idea of how a tribunal might shorten that timeline in comparison to going through a federal court process?
Thank you again for the question. I can only answer, unfortunately, in the most general sense that we obviously have all likely been exposed to court cases and appeals that can take many, many years to move through both the initial decision system and then the follow-on appeal systems. It's possible for them to drag it for many years. Currently, the first level court takes up to 2 years to engage. We would think that a tribunal could be much more rapid than that, particularly because it would cut down on the number of follow-on appeals that would go after the tribunal's decision.
Thank you for that. I wanted to ask you another question, which was, again, to differ with Mr. Williams' opening sort of remarks when he introduced the amendment. I think he claimed, and maybe I'll use his wording here if I can find my notes. He said, I think he said, well, it would make us an international outlier. He also said that it would delay justice, which I think we've talked about. But I think he also said something. I'm sorry, my notes are not as clear as I thought they were. But that the efficacy of the OPC, the power of the OPC, would be somehow diminished by having a tribunal in place. And I'm not sure that that's true based on my reading. My understanding is that the CPPA, what it's proposing, gives the OPC quite a number of new authorities and powers that are above and beyond what the OPC has had in the past. So could someone just list and unpack the specific new powers? And then I have a couple of follow-up questions to that.
Thanks very much for the question. So new powers afforded to the commissioner would include the ability to issue binding orders following investigations. As I mentioned earlier, that can order an organization to do something to comply with the CPPA. It could also order an organization to stop doing something that violates the CPPA. The commissioner would also have the ability to enter into compliance agreements. As I mentioned earlier, there are government amendments that have been tabled that would allow for those compliance agreements to be entered into at any stage through the process, and also allow for financial considerations to be included within that compliance agreement. That means that, for example, an organization that was found to be in contravention of the CPPA, the OPC would have the power to negotiate a compliance agreement that could include a financial payment or penalty in essence. All of those things are new powers that the OPC would have as a result of Bill C-27 that are currently not available to the commissioner. On the issue of alignment with other jurisdictions, as I pointed out earlier, we should always be very, very cautious to think narrowly about alignment on any one specific issue. We do see tribunals in effect in the privacy space in the UK, in Ireland, in Australia, in New Zealand, that are very analogous to the approach that's being taken here with some slight variations across. But again, every jurisdiction has its own constitutional framework and other laws in place that drive those slight variations. The point is that we are taking into account the best practices and the best approaches that have been undertaken internationally, as well as undertaken significant consultations here in Canada to bring forward a proposal that we think significantly improves the enforceability of Canada's private sector privacy law and gives the commissioner significant new powers to do so.
So, but so thank you for that. And so it's binding orders, compliance agreements that may include monetary penalties. And I understand that the tribunal would only come into effect if there was an appeal or there was some question around what rate at which to set that monetary penalty, or what? Is that correct? Are those the only two cases that the tribunal would come into play?
That's right. I think in practical effect, you can imagine scenarios in which a company does not agree with the commissioner's position on what the compliance order should include, for example. And so if the commissioner were in a position of not being able to negotiate such a decision or outcome, the commissioner could then recommend an administrative monetary penalty to the tribunal, or the individuals involved in the case or the companies involved in the case could seek an appeal to the tribunal. But as previously pointed out, those are the two points at which the tribunal could be engaged. And in both instances, we find that they would be more efficient and effective in doing so than the alternative process.
So in some sense, is the tribunal actually enhancing the OPC's efficacy to actually utilize the powers, the new powers that the OPC would get as a result of the CPPA? Or is this a check and balance situation where those powers are somewhat limited by the tribunal? Because I think what was implied was that essentially by having a tribunal, at least as I understood Mr. Williams' intention when he made his comments, was that somehow this would take away some of the power from the OPC. And I'm not sure that that's the case. First of all, we've already established the OPC is getting significant new powers. So the powers that the OPC would have as a result of the CPPA would be enhanced by this legislation. But then even in an environment where the OPC hadn't had those powers in the past, it may make sense to build trust in a relatively new system in Canada to ensure that those powers are checked or that have some limitations. But I can even speculate that there may be some ways in which the monetary penalty may be more fair as a result of having a tribunal look at how to set that at the right level. So it's an open question. I really don't know exactly what the answer is. It's a legitimate question.
Thank you for the question. I think probably best to consider it in two ways. One, when we talk about the ability to set the administrative and monetary penalty that would be done by the tribunal, I think you're quite right that is a check and balance piece. That is about fairness. That is about expertise in setting the appropriate monetary penalty. When it comes to the appeals process, I actually think, again, you're quite right that it does, in effect, speed the finalization of an outcome than it would otherwise by following the court system. Because the decisions of the tribunal are final, it does, in fact, offer significantly more speed and efficiency and effectiveness in getting to the outcome. And through that, one could suggest that actually the OPC's powers and ability of the commissioner to get to a final decision and to influence what's happening in the market and to get companies to comply, it is in fact speeded and aided by having a tribunal system rather than having to work through multiple layers of court systems via appeal.
Thank you. Okay, so one other question related to this is, I note that some other members on this committee have noted the number of cases that have sort of been contested in the federal courts. Now, I think it's kind of misleading to use that as a way of determining the volume of disputes that there might be, given the fact that we're discussing here a new legislative framework wherein the old one in Pepita was 20 years old and didn't account for the digital age that we're in. It didn't account for many of the breaches in privacy that may happen throughout our economy today more frequently. So I think you know, when you're introducing a new legislative framework that comes with the OPC having new powers and authorities, you have an old legislative framework that was not suited for the age that we're in. My impression would be that there could be a lot more volume of disputes that both the OPC and a tribunal might deal with in the future once we hopefully get through installing this new legislative framework. So can you unpack that for us and whether you think that volume of disputes would increase in the future likely? And again, like I could see a case to be made for if we think the volume is going to increase, which I suspect may be the case, then would we want all of those disputes to be going through a federal court system rather than having a tribunal in place, which significantly speeds up the process and gets to outcomes and increases trust and transparency in a system that is relatively new?
Thanks again for the question. I think it would be it's very fair to say that the OPC is getting significant new powers, that those powers include order-making powers and the ability to recommend administered monetary penalties, which are significant changes from the current approach where, as my colleague earlier pointed out, the OPC does not have those abilities. I think it's likely that companies may be more motivated to undertake appeals of that and to try to seek different outcomes because of the nature of how they could be impacted by the OPC's new powers. So I think it is quite reasonable to suggest that there might be more activity in terms of follow-on appeals.
Chair, just to check, are we having a vote soon? Just double checking the time.
Well, we are supposed to, but the bells are not ringing.
Oh, they're not. Okay. We'll keep going then. So my understanding is that other jurisdictions also have a tribunal in place. You know, we've heard, well, Mr. Williams was saying that we would be an international outlier, but based on my understanding and based on some of the things that you've said already, that is not exactly the case, maybe not the case at all. Could you clarify for us any of the other tribunals and how things work in those other jurisdictions? I know you've mentioned New Zealand and Australia, but are there any others that you could reference?
Thanks again for the question. As you correctly pointed out in the question, Australia and New Zealand are both analogs that we've looked at that have tribunal mechanisms. The UK has a tribunal mechanism that's organized slightly differently than what's being proposed under CPPA. Again, as I pointed out earlier, different jurisdictions have different kind of constitutional frameworks that can drive those differences. I think it's also important to recognize that when we're looking at analogs around the world, a lot of the privacy rule sets or legal frameworks have very different applications, very different scope, and therefore would necessitate different kinds of oversight mechanisms. So a good example that we referenced earlier today was California, which has come up in this committee a number of times over the last few weeks. California's administered monetary penalty regime is capped between $2,500 and $7,500 per transgression. At that level, it may not be necessary to have a body of expertise dedicated to understanding the issues and determining the right level of monetary penalty that would be applied. In this case, under CPPA, we're talking about going up to $10 million or 3% of global revenues. That is a very significant impact, and I think a degree of procedural fairness would be expected, and that's why the tribunal is a core part of the government's proposal.
So I understand that based on what you've said, there's administrative tribunals in the UK, Australia, New Zealand, Ireland. You've pointed to the model in Quebec as being slightly different, but effectively an administrative tribunal. But there's also, I think, other federal level sort of jurisdictions or areas. I think there's several other areas where administrative tribunals are used. Can you maybe talk about any of those other examples, like within agriculture, for example, or any of the others that you know about?
Certainly. Thanks for the question. I have mentioned tribunal models or administrative tribunals in spaces in Canada, federally, like spaces like agriculture, transportation, and international trade. I'll turn to my colleague for some specifics on those.
So the first one is obviously in competition as well, and I think we've talked about that. Another interesting example is the CRTC, which is also an administrative tribunal. What's interesting is under Canada's anti-spam legislation, there's a chief enforcement officer, which kind of has all the powers that the OPC would have. So conducts the investigations, issues notices of violation, and makes recommendations potentially for AMPS. But it's the tribunal that actually makes those decisions, again, as a sort of oversight mechanism. So again, and it's again very, very similar to the CIE model in the sense that there is an appeals mechanism within the organization, like the CRTC. But it's in one organization as opposed to having two different organizations. And the Competition Bureau is another example where there are two different organizations. There's the Competition Bureau, and then there's the Competition Tribunal, which performs the same function.
Thank you. So on a slightly different topic, I note that I think this amendment also removes the private right to action. Can you speak to the importance from a principal's perspective of having that incorporated into, like, that seems to be a pretty important piece of the legislative framework that kind of hangs together. Can you maybe speak to the importance of that?
Thank you again for the question. The importance of maintaining a private right of action was raised by civil society stakeholders throughout the consultations that have taken place since 2018. It's also been raised as an important feature by the Office of the Privacy Commissioner. Having a private right of action, because the way that the law is set up, although it's possible for the commissioner to recommend an administrative monetary penalty, that's not going to compensate an individual who may have been kind of suffered a transgression of the act on their own personal information. It wouldn't do anything to make them whole. And what a private right of action does, is it's proposed in the bill, would be to allow, on the basis of a decision and a finding taken by the privacy commissioner, it would allow the individual in that finding to be able to go and then seek awards or compensation on the basis of the impacts that they faced through the transgression of the law.
So essentially, they wouldn't be able to seek rewards for breaches of their privacy as a result of this amendment? Is that what I'm hearing?
If the proposed amendment in CPC 9 were to move forward, it would remove the ability for individuals to take a private right of action in these situations. That's right.
Seems pretty counter to what I've heard some members on this committee say they would like to be able to protect, I think, which is the fundamental right to privacy. So, okay, well, I really appreciate your testimony. Maybe the last thing I'll just ask, because it's still nagging in my mind, Mr. Williams and Mr. Viss, I think, implied that the OPC doesn't want a tribunal. I think Ms. Angus had said, well, that's not exactly correct. Can you just sort of square that for us? Because it seems like, you know, that's kind of a fundamental disagreement here. Where does the current privacy commissioner, Mr. Dufresne, who I have a lot of respect for, you know, I would love to know, how do we ensure what is the current privacy commissioner's perspective on the tribunal? Can you give us just the highest overview of that again? I know you've already said, but it seems like there's a difference of opinion about what the privacy commissioner has said, and it would be helpful just to clear that up once and for all if possible.
Sure. So the Privacy Commissioner last year published 15 recommendations that were his top priorities with respect the top priorities that he, or top changes that he wanted to see in the CPPA, and none of them requested the removal of the tribunal. What it did request was two things, one with respect to the tribunal and one with respect to his other enforcement powers. So with respect to the tribunal, what he said was he would prefer the tribunal decisions to be appeal to the Federal Court of Appeal rather than the federal court, which is currently the system. And as we've said, it's not an appeal; it's a judicial review, so it's not quite the same thing. So that skipping a step is not really going to make it faster because it's not an appeal. The second recommendation was about giving more flexibility with respect to compliance agreements. Specifically, he wanted to be able to enter into a compliance agreement at any point in time, and he wanted financial consideration, so kind of the equivalent of AMPS, to be part of a compliance agreement that he could conclude. And there are government amendments to that effect.
So is there any, I guess, residual disagreement in terms of what the OPC has recommended and what approach is currently being taken in the CPPA?
So it would be the OPC recommendation that asked for the decisions of the tribunal to go to the Federal Court of Appeal. That we would not do. My understanding is that would require an amendment to the Federal Courts Act, which is not under consideration at this time. So we couldn't amend the Federal Courts Act to that effect. And we are not, and at the same time, from a policy perspective, that's not necessarily going to speed up the process because, as we've discussed, it's a judicial review and not an appeal.
So, and just to clarify again, the OPC did not ask for taking out the tribunal out of this legislation.
That is correct. The current commissioner did not ask
okay.
For that.
Thank you.
Merci beaucoup, Monsieur Turnbull.
Thank you, Mr. Turnbull. Mr. Garon, the floor is yours now. And then I have Mr. Perkins and Mr. Viss. Thank you very much. I'd like to come back to what Mr. Turnbull mentioned. I think these are good questions that have been raised and that they've been necessary. We've talked a lot about the number of cases that were treated by the commissioner under the current system, and that's a question that I asked to the parliamentary secretary, to the deputy minister, and to the minister as well. And so by changing the legislation, there may be more cases, and there's jurisprudence to be built and case law to be built. So, and then there's a question of the expertise. In my mind, whether it's at the tribunal or the commissioner, that expertise has to be built. So what interests us is to know what expertise has been built at the commissioner's office. I'd like to know how many decisions by the commissioner went to federal court, and among those decisions, how many were invalidated? Well, first of all, we have to specify that the commissioner has no decision-making authority. So that's something that it's important to point out. What the commissioner does is he publishes a report, an investigative report, essentially, with recommendations. And if the company does not want to follow those recommendations, that's where the commissioner can bring the company to court, or the complainant can bring the company to court. So we looked at this question, and we saw that between 2003 and 2024, there were 50 decisions where the commissioner, or there was a complainant, but there was an investigative report from the commissioner. So about 50 decisions, and in 70% of the cases, the court did not agree with the investigative report of the commissioner. And more recently, in the commissioner versus Facebook, the federal court decided that the commissioner had not really proven his case. He didn't And it's specified that I should point out that the commissioner appealed that decision, and we'll see how many years it takes. We might have to wait for a long time to get a decision. Now, this is not something that happens every day, but it happens quite often. Okay, so what you were referring to, and I'll say this in English. So essentially what you're saying is that when there's a review that's done by a court, I'd like to have those statistics with the list of decisions, if that's okay with you, and for the committee and out of personal interest. And I should point out that I've already asked this and I never did get it. So the court invalidated a number of the decisions by the or recommendations of the commissioner. And now we want to create a new tribunal by invoking, among other things, the alleged fact that the federal court does not have expertise. So explain that to me, please. I'm not a lawyer, but from a logical perspective, it seems a little bit shaky as a justification. It's a question of efficiency. It's a question of expertise as well. Well, I'm asking you the question because this has happened a number of times. You said that we needed a new institution with new people named, new appointees, and a new system because the federal court, and I'll explain my reasoning to you. The federal court apparently does not have expertise in this field, but I am under the impression that creating a new institution and could have the effect of removing credibility from the commissioner. So, or from the court, rather. So we're saying that the commissioner's decisions have often been invalidated by a federal court, but you're saying that you prefer, that's to the common person. It's makes no sense. Well, first of all, I think you have to admit that we're talking about two different things. First of all, administrative and monetary penalties. And then the second is, and both are different, appeals, sorry. And the point that we're trying to make here is that the expertise required to be a real expert for penalties, that's an expertise that could be developed in the tribunal. Oh, okay. Mr. Garon, just a second. As you see, the bells are ringing. So they started at about 6:42. So that brings us to the end of our session. So I think we should be adjourning at about 7:05. But I need your unanimous consent to continue to 7:05. Do I have unanimous consent?
Until about 7, more or less.
Yeah.
We're good?
Yeah, 7 o'clock.
Okay, thank you.
Bon,
Okay. So I don't want to, be impolite and to interrupt you, because I think this is an important discussion. I think we have to we have to use our time wisely. I don't understand why we could build that expertise starting from nothing in a new tribunal, but not at the CPO, or the OPC rather. All right, thank you again for the question. We're not distinguishing between the commissioner's expertise and that of the tribunal. The tribunal would show deference to the commissioner's knowledge.
Give deference to the commissioner's decisions. In other words, the tribunal is providing more respect and to the expertise of the commissioner by deferring to the facts and decisions and determinations made by the commissioner. The second point about expertise is that the tribunal would see all of the cases related to privacy infractions and breaches. They would build that expertise and awareness and understanding over time versus a scenario in which a court or any court could be sought to sit on a given case, any judge. That is a very, very significant distinction. So it's about expertise in at least three ways in this case. The expertise to develop a facility to identify the right administrative monetary penalty. The expertise resident in the commissioner becomes more respected because the tribunal must give deference to the commissioner's findings and facts. And third, that the tribunal itself becomes a much more expert body in hearing these appeals because it sees every single privacy
OK,
case.
je comprends. Donc, ce que vous me dites,
OK, I understand you.
Which is in the European system of the General Data Protection Regulations. Ireland has a system where the commissioner, their privacy regulator, can't levy a fine directly and must go to seek an adjudicated body to determine the level of the fine. They have the highest level of GDPR fines in Europe. So the ability to work through these processes doesn't necessarily in any way suggest that you're going to have reduced fines, as may have been suggested at this committee earlier today, or that you're going to have slower decision making. What we see internationally is just the opposite, in fact. That actually the commissioner's work is strengthened by having an expert tribunal working on these issues exclusively.
OK. Donc, ce que vous nous dites,
Okay, so what you're saying essentially is that by creating this new institution, since the decisions will be on a limited number of topics, case law can be built more quickly than in federal court. I think we could be doing that at the commissioner's office too, but okay, let me move on to something else. So with regard to deference, that would not reduce the role of the commissioner because the tribunal that would be created by the Act would pay deference to the commissioner, and that would help to determine the AMP. So the first function would be to determine the level of the AMP and to deal with appeals. So both functions would be distinct. So the AMPs and appeals.
Je suis désolé pour mon anglais en ce cas.
Sorry for my French, but okay. So essentially, or it was alluded to at least, that to have penalties that are more fair and more appropriate, the new tribunal would have the ability, would have the power to act more fairly, and it would be looking at questions taken by the decision. But you know, if we go to 63, Article 63, it says the tribunal can reject an appeal or substitute its own conclusions, ordinance, or decisions. So essentially, it's not really true. I understand that you're trying to explain the legal meaning of deference, but what was explained earlier today was not that at all. The committee, in reality, this new tribunal doesn't really have any more expertise because it just invalidate what the commissioner has said. So 63.1, that's where, and I'll repeat it. So can reject the appeal or substitute its own orders and so forth. Well, there are 2 points that I would like to specify. If you look at 2, so, and the interpreter apologizes, he does not have the text in front of him. So that clause it defines what the applicable norms. So the applicable norms, or the applicable standard rather, is the right decision in terms of questions of law. And it's a very strict standard, but so there's also the manifest error. So yes, I understand. Okay, so that's the first point. My second point is this. We talked about expertise and that expertise would be built, but the tribunal would begin with a certain amount of expertise because there would be 3 to 6 people, depends on who's appointed. So those people, 3 people would already have to have expertise. So it's not to be built, it's not to be built from scratch. There are people that are going to be starting with expertise on the topic. Yes, and we saw examples in Quebec of Quebec judges that may not have good level expertise. But okay, so what would, so as us as legislators, what would keep us from the act from those same standards could be, what would stop the federal courts from applying those same standards? Okay, so 2 things. From a very technical perspective, I think we'd have to amend the Federal Courts Act because it's that act that dictates how the court judges decisions. So that's a technical answer. But in terms of administrative law, there are principles as well. So like as is done in Quebec, we'd have to specify the roles and responsibilities of each division to create that separation between investigative functions, decision-making functions, and then how the federal court, what standards would the federal court apply? I'd be interested in learning more about that, but I don't think we'll have time to do that today. But you know, we have 3 acts here in this piece of legislation, and it's difficult. So I think it's complicated. So that's all for me today. Thank you very much. I appreciate your answers. Thank you, Mr. Perkins.
Thank you, Mr. Chair. The Federal Privacy Commissioner, would you consider to be an expert in privacy and privacy processes?
I think that's a fair statement.
And would you feel the same way about provincial privacy commissioners?
Again, I think that's a fair statement, but I would rather not engage on it in the generics. When we think about the different powers that each of those commissioners have, the different systems in which they function, for example, not all of them have the ability to impose administrative monetary penalties, Alberta and BC, for example. So when we're talking about degrees of expertise, I think it's important that we be really clear about where the expertise lies and on what domain we're speaking.
I don't want to interrupt, but can we just let the witness finish?
Well, I only have
his
5
answer?
minutes till we adjourn, so he's not answering
Rick,
what I was asking.
I'm really respectful. Like, just if you wouldn't mind letting him finish answering without cutting him off, I would appreciate
Thank you,
it.
Mr. Turnbull. And a point of order is not a debate between MPs, but yes, please, Mr. Perkins, allow Mr. Chaba to conclude his thoughts.
Thank you, Mr. Chair. I was simply trying to make the point that I think it's important that we think about domains of expertise very specifically. We are talking about a specific question and make sure that the voices that we're talking about in that question are actually avowed experts in the area that they're talking about. So if we're going to be talking about things like having a tribunal, for example, or having an administrative monetary penalty regime.
Let me pose my questions, if I could. Thank you. So I understand all of that, and there are different systems, but privacy commissioners all talk to each other. They're not some sort of independent, isolated person. In fact, they talk to each other around the world. And I'd just like to, and I'm sure you've read this, but in the current privacy commissioner's submission on C11 in 2020, he wrote, the central issue in the design is as follows. In order to enhance consumer confidence, we believe that the decision-making system for adjudicating complaints should be as fast and efficient as possible. In order for individuals to have confidence, they would expect there to be real and timely consequences when the law is violated. Of course, the system must also be fair to businesses. Over a 40-year period, the OPC's performance in this regard has been excellent, and we welcome making our procedures more transparent and consulting on ways to enhance them. We would also be prepared, should Parliament grant us the power, to impose monetary penalties to have to take into account any relevant factors beyond those as set out in this particular section in that bill, previous bill. So, in our opinion, the design of the decision-making system proposed in the CPPA goes in the wrong direction. By adding an administrative appeals tribunal and reserving the power to impose monetary penalties at that level, the CPPA encourages organizations to use the appeal process rather than seek common ground with the OPC when it is about to render an unfavorable decision. While the drafters of the legislation wanted to have informal resolution of cases, they removed an important persuasive tool from the OPC. Moreover, this design is outside the norm where compared with other jurisdictions. We have a lengthy discussion on that already. Given these considerations, our primary and strong recommendation is to remove the provisions relating to personal information and data protection tribunal from the previous bill, Bill C-11, which has been put forward again. And then when the Privacy Commissioner appeared before this committee on October 19th in 2023 last year, I'll quote from him. He says, "Third, there remains the proposed addition of a new tribunal, which would become a fourth layer of review in the complaints process. As indicated in our submission to the committee, this would make the process longer and more expensive than the common models used internationally and in the provinces. This is why we have recommended two options to solve the problem. The first would be to have decisions of the proposed tribunal reviewed directly by the Federal Court of Appeal, and second would be to provide my office with the authority to issue fines and to have our decisions reviewable by the federal court without the need to create a new tribunal." So he's an expert, but that is also shared by the former Privacy Commissioner when he appeared before this committee, and he also pointed out that every provincial Privacy Commissioner opposes the tribunal. In fact, specifically, the Information and Privacy Commissioner of Alberta stated before this at meeting 104, "We are concerned about whether the inclusion of the tribunal as an appeal body to the Privacy Commissioner orders would impact our ability as a provincial Privacy Commissioner to conduct joint investigations." So there's a lot of opposition to this, and that's what we've heard. So I'm at a loss to see almost anybody who's an expert in this has said this will lengthen the process and make it more difficult. Everybody except the government.
Well, thanks for the question. I think we've been really clear in explaining our rationale for why we think it would be more efficient in this model. I think we've also been really clear to note that in some cases the provincial commissioners don't have an administrative monetary penalty power, the power to issue administrative monetary penalties. The previous commissioner was reacting a number of years ago to a different bill and a different approach. The current privacy commissioner has outlined an interest in seeing compliance agreements be more flexible in their approach. The government's amendment does, in fact, propose to make that a feature, as my colleague Ms. Angus pointed out earlier. The ability to change kind of the level of appeal to the Federal Court of Appeal rather than the federal court, which is also something that Commissioner Dufresne has pointed out, is not something that can be done in this proceeding because Bill C-27 doesn't actually open the Federal Courts Act. But the other approaches that Commissioner Dufresne has highlighted have in fact been taken on board. In our conversations with the Privacy Commissioner suggest that there is an openness and an understanding of why this could be important. In fact, in his most recent testimony to this table, the OPC himself suggested that since the bill provides the authority to issue orders and significant fines, more procedural fairness may be warranted. To address that concern, the government could say, yes, more procedural fairness is needed. That's the model used in Quebec and other parts of the world. So even in his own testimony before this committee, he did in fact raise that issue and acknowledge that there could be good reasons for doing so. I would also point out that in your commentary earlier, the way it was presented made it seem like the commissioner could not quickly act. And in fact, the exact opposite is true under CPPA. The commissioner can quickly act to issue orders, both compliance orders and stop orders. So this notion that somehow this appeals process or this tribunal function would slow down the ability for the commissioner to act in situations that are, requiring speed is not the case. And this notion that somehow investigations or joint investigations would be impeded only because an administrative monetary penalty, which by the way would always be set distinctly anyways. So the ability to collaborate on an investigation is not at all hampered by having a tribunal in place. The only thing the tribunal is responsible for is determining the ultimate amount of any given administrative monetary penalty.
I just want to, that we're going to vote, but I just want to say, because I'll continue the next meeting on this, that wasn't my presentation. That's the testimony of the Privacy Commissioner. Just want to correct you there, because you made it seem like it was mine. I was quoting the Privacy Commissioner.
On this note, I'm sure we'll have the chance to continue this interesting discussion. Thanks to our witnesses for being with us today, and we'll see you next week. This meeting is adjourned. Thank you, everyone.
Trying.
Yeah, so it's a big.